Grounds of restrictions on freedom of profession, occupation, trade or business, Article 19(6). Under Clause 6 of Article 19, the state is authorized to impose reasonable restrictions on the right to carry on a trade, profession or business. The condition is that the restrictions must be 1. Reasonable, and 2. In the interest of general public. The right to carry on business, being a fundamental right, its exercise is subject only to the restrictions imposed by law in the interest of the general public under Article 19(6). In determining the reasonableness of the restriction imposed by law under Article 19(6), the court cannot proceed on a general notion of what is reasonable in the abstract or even on consideration of what is reasonable from the point of view of the persons on whom the restrictions are imposed. The expression in the interest of general public in Article 19(6) is of wide import, comprehending public order, public health, public security, morals, economic welfare of the community and the objects mentioned in Part 4 of the Constitution. Nobody can dispute a law providing for basic amenities for the dignity of human labor as a social welfare measure. The tests of reasonableness have to be viewed in the context of the issues which faced the legislature. In judging their validity, the court must approach the problem from the point of view of furthering the social interest which it is the purpose of the legislation to promote. In Nagar Rice and Flour Mills vs. NTG and Brothers, AIR 1971, the government issued an order under Section 8(3)(c) of the Rice Milling Industry Regulation Act 1958, sanctioning the change in the location of the rice mill from its original site to the new site. The respondent challenged the order on the ground that appellant's mill was moved to a place in the vicinity of their rice mill, and in consequence of the removal of the appellant's mills their business was likely to be adversely affected, and this amounted to unreasonable restriction on his right to carry on business. The court held the order valid. The owners of the rice mill shifted its existing location and obtained the necessary permission for the change of location from the Director of Food and Civil Supplies. Even if it be assumed that the previous sanction has to be obtained from the authorities before the machinery is moved from existing site, the competitor in business, owner of another rice mill, can have no grievance against the grant of permission permitting the installation on a new site. The exercise of right under Article 19(1)(g) is subject only to the restrictions imposed in the interest of general public and not that it adversely affects others' business. The pursuit of any lawful trade or business may be made subject to such conditions and restrictions as may be deemed essential by the legislature to be in the interest of general public. In order to determine the reasonableness of the restriction for the purposes of Clause 6 of Article 19, regard must be had to the nature of the business and condition prevailing in the particular trade. It is obvious the nature of business must differ from trade, and no hard and fast rule concerning all trades can be laid down. The facts and circumstances present in trade, the type of the evil attempted to be remedied, the degree of harm likely to be caused to the citizens should determine the scope of restrictions to be imposed by the state. All the attendant circumstances should enter into legislative prescription of reasonableness of a restriction. Accordingly, it has been held that a law which gives preference to government over the private traders in allotment of wagons for transporting coal does not amount to imposition of total ban on business of supplying coal by the private traders and imposes only reasonable restrictions on their right to carry on trade under Article 19(1)(g), and hence valid. The railway is not the only means of transport. The petitioners' trade as coal merchants is in no way interfered with by the railways by not being able to provide transport facility. There is no fundamental right to carry on trade or business in noxious and dangerous goods like intoxicating drugs or liquors. Thus trade in noxious and dangerous goods, adulterated food, trafficking in women may be prohibited altogether by the state in the interest of the general public. The trades which are neither immoral nor injurious to the health and public welfare cannot be suppressed or prohibited. They can only be regulated and their evil effects, if any, be mitigated. Some occupations by their very nature of being noisy and dangerous may require regulation as regards the locality in which they should be practiced and special conditions in which they should be carried on. No citizen has right to carry on his business at place of his choice if his doing so is injurious to the public health or even cause inconvenience to others. The state has power to enforce an absolute prohibition of manufacture for sale of intoxicating liquor. The state has the exclusive right or privilege to manufacture, store and sale of liquor and to grant that to its license holders on payment of considerations with such conditions and restrictions for its regulation as may be necessary in the public interest.